All right, so today we're going to talk about estate planning in times of crisis. At least one of you is an existing client, and I can assure you that everything I'm going to tell you is already taken care of for you. But in this time of important that people who have not yet done planning for quite some time, that they take a look at what their plan is or what might need to be improved in it, especially what I'm going to call the minimal things that might need to be taken care of. So Bronte, if you will change the slide for us, please. So we're going to talk today about estate planning for individuals and families. And the very first thing I want to bring home is that I think that every adult in the United States should have a power of attorney and a healthcare power of attorney. That's one of the reasons we're providing free of charge a healthcare power of attorney form as well as a living will form. The power of attorney for legal and financial affairs, which is the other power of attorney we recommend, is a much more complex document and not one that I felt comfortable sharing as a basic form. There's a lot of counseling, a lot of individual design, or at least a fair bit of it, that should go into doing a power of attorney for legal and financial affairs. And that's why it's not something we just throw out as a form. But the form for the healthcare power of attorney and the living will is pretty robust. We think it covers everyone pretty well. I have formatted it in a way that the healthcare power of attorney only needs to be signed. It doesn't need to be notarized, although there is a place to have it notarized if you can get that done. Having it notarized does not make it more official, but it's always my view that things that are notarized tend to make the bureaucrats sit up and take notice a little bit more. But a healthcare power of attorney is legal without witnesses or a notary. That is not true, however, for a living will. Here in Colorado, for a living will to be valid, it has to be witnessed by two people, and those two people have to be disinterested witnesses, which comes down to the fact that they can't be close relatives, and they can't be someone who might be responsible for paying for your health care bills, as well as someone who is actually providing you with health care at times. So it's harder to get disinterested witnesses in this time of the pandemic. But the other thing I want to point out to people is that the living will witness it, wishes, because the doctors are really more likely going to be listening to your healthcare agent under the power of attorney than they would be listening to the document that you provide anyway. That's why I say doctors listen to people and not paper. It's not that the living will isn't legal. It's a lot of law written into our statutes about living wills, but the truth of the matter is when the rubber hits the road, the doctors are more likely to listen to what your agent says. So even if you can complete the living will and sign it and show it to your agent or tell your agent that you have it, it can at least go a long way of letting your agent know about what you want and giving your agent some both legal and moral authority to accomplish what you're trying to accomplish. Bronte, can you change the slide for us, please? Those of you on Facebook Live, you do have the slides on a separate post, but I'm not going to say anything that you really need the slides for. It's just more or less to keep us all on track, particularly me. So the other thing I want to bring home to everybody is now is a good time to review your existing documents. Not only because you might be home more and have more time to do it, but because this is the time when it brings home the need to have these documents and to know that you have things in place. While you're reviewing them, you may be asking, well, what am I reviewing it for? And that's why we send you or have available to anyone our estate plan checklist. Those are the action steps that we think are important to keep your current plan current and effective. That is, what kind of documents do you need and what should you be looking for in those documents? And the checklist is there, but I'm just going to briefly go over some of the things that it covers. First off, what are the documents you absolutely need? And this checklist is more about minimums than it is about ideals. What is the documents you at a minimum absolutely need? In my view, you absolutely need a will. Even if you have a living trust, you need a will because we call that the pour-over will or the pooper scooper will, designed to make sure that something that isn't in your trust when you die would still end up in your trust. A will covers all of the assets you own that don't have a beneficiary that aren't in your trust. So you have to have a will to help direct those assets. If you don't have a will, the state gets to tell you what it's going to happen. It doesn't go to the state, but the state has its own plan, and it may not fit you. As I've said, I think every adult should have a power of attorney. That includes your 18-year-olds, 19-year-olds, 20-year-olds who might be living at home or in a dorm or on their own apartment, because they may not think they need a will, and they may be right because they don't have any assets yet, but they do have legal and financial affairs and healthcare affairs that might need to be handled if they got too sick to act. Who, for example, would access their bank account? Who would contact their landlord? Who would just be able to collect on something that's owed to them? So those are the reasons that even young adults, ones we may not think of as having anything in terms of assets, should be doing a power of attorney at the minimum. In addition to a healthcare power of attorney, we recommend that your documents reference HIPAA. That's the Health Insurance Portability and Accountability Act. I looked it up to do this program, and I realized that that came out in 1996, so it's been out a while. But if you haven't had your documents looked at for a while, or even some of the newer documents don't always reference HIPAA and the need for someone to have access to your healthcare documents, your private healthcare documents. So it's a good idea that you have something that says, under HIPAA, I'm authorizing these people to have access to my private healthcare documents, especially not just your healthcare agent, but your agent under the legal and financial power of attorney, because that person may need to know something about your healthcare, both to get your healthcare bills paid, but also because they need to know more about your prognosis. Are they planning your estate and your assets because you may live for another 5, 10, 15 years? Or are they aware that your time is short, which will have a difference in how they manage your finances? So that's something that I suggest you have as well. The living will that we sent out to you is a document that describes what kind of care you do or don't want in the time of end of life. Do you want care that will prolong your life? And that's something that a lot of people choose to have. There's no right answer as to whether you should have one, but more whether if you want one, then you should have one, because that's not something people can create in a vacuum. The things you should be looking at if you have these documents, if you're reviewing them, what are you looking for? Well, you're looking for who's named in the roles. So in your will, you'd be looking for who's named as your personal representative. In your trust, you're looking for who's named as your trustee. In your powers, who's named as your agent. Combined, all those roles are called fiduciary. A fiduciary is a person who's acting in a position of trust. And all of those roles, your personal representative, your executor, your trustee, your agent, are in positions of trust. But take a look at your documents. Who have you put into that job? Is that still the person you want to do that? Every now and then I get a client who looks and goes, oh my goodness, we named so-and-so. We're not even talking to so-and-so. We better make sure we don't have so-and-so in that position anymore. So I want to make sure that you take a look at that and that you've got the right person in that job. The other thing to think about is, do you have a second choice? What if that person can't fill that job? Do your documents have a backup plan written into them? And that's something that I suggest you take a look at and try to figure out you've got there. The other fiduciary role that some people may have in their documents is that of a guardian. If you have a minor child, or if you have a disabled adult child for whom you are currently acting as a guardian, then your will is the place to nominate a successor guardian. If that's important, if in your life, based on your circumstance, take a look at that. Do you have a guardian named? If so, is that still the right person? And do you have a backup if you can come up with one? Those are things to think about. Then just take a look at what lawyers call the dispositive provisions, which means the part that says, this is what to do with my assets when I die. Okay, what does it say should happen? Is that still what you want to have happen to your assets? If you named a person who's going to inherit your assets, do you have a backup plan there? What if that person predeceases you? What does your will say about what should happen in that instance? Then we're going to talk about updating, but one of the most important updates that I think has to happen in a lot of plans, including a lot of plans that I did, is that a lot of the plans that call for a trust to inherit, meaning that, let's say I've named my son to inherit half of my estate, but I've said he should inherit it in the form of a trust that continues for the rest of his life. In fact, that is exactly what my plan says. And that kind of trust, which is what I go to call a blueprint trust, what the law calls a testamentary trust, is one that doesn't exist right now. It's just one that we've written the blueprint for in my documents. So we know what to build when I die. But right now, since December of 2019, we've had some significant changes in the law that can affect how those trusts are taxed if they get any money from a retirement plan. So a lot of those will need to be reviewed and taken a look at to see if they need to be changed. That may need to have a lawyer look at them to decide if they do need to be changed, because it's a fairly obscure sentence in some of the language that will tell you what has to happen there. Another thing that a lot of people don't look at, and this is a great time to do it, is to look at your beneficiary designations and how assets are titled. So it's important to know, do you have the right people named as the beneficiaries? Because if you haven't looked at it for a while, that may not be what you have in mind. And also because it may not, you need to understand that the beneficiary designations of a retirement plan or life insurance, those take precedence over what your will says. So if my will says that I'm going to divide things 50-50 between my two children, but I have a life insurance policy that says it's going to my brother, that life insurance policy is going to my brother, regardless of what my will says about my children. So you want to make sure that your beneficiary designations line up with what you want. Remember how I said that my plan says that I want my son to inherit in the form of a trust? Then I need to name that trust as the beneficiary if I want that trust to hold it for him upon my death. And so those are things that need to be lined up. If you have done planning with us, we gave you a follow-up letter, or you have funding instructions in your red book that'll help you understand how to do that. And of course, if you're part of our care plan, we're helping you do that anytime, all the time. So the other things I want you to think about in terms of looking over your existing documents is, if you got married or divorced recently, it's definitely time to review your existing documents. Do they reflect your new marital status? If you have pets, have you given any thought to what's going to happen to your pets in the event of your disability or your death? You can provide for them in your will and in your power of attorney, and I highly recommend it. Okay. If someone is inheriting governmental benefits, then you might want to consider having them inherit in the trust that we sometimes call a supplemental needs trust. And that means that they won't inherit so that they have full access, but they'll inherit in a way that they can go to the government and say, I can't touch that for all these reasons, except for supplemental needs, and so you need to let me have a look at it. Okay. Bronte, can you change the slide, please, and let Pat in from the waiting room? All right, we'll go back up. Okay, so we did talk about the minimum recommended for most people. Okay, you need the will, you need the power of attorney that covers legal and financial affairs. Oftentimes you'll hear the literature call that a durable power of attorney. I hesitate to use that because both the legal and financial power of attorney and the healthcare power of attorney are durable, meaning that they are specified to be effective even when you are disabled or incapacitated yourself. That's what durable means. Since both of those powers of attorney are supposed to be effective and durable, I don't like to distinguish one as durable and then say the other one is healthcare. So you'll hear me refer to the one that isn't healthcare as the legal and financial power of attorney. Monty, can you change the slide, please? All right, the other thing I want you to think about is beneficiary designations and titling. It's not that some people will say that they don't need a will because they've done everything by beneficiary. And that can include like a beneficiary deed, which is a deed that you record now that says my real estate in Colorado, I want it inherited by this person as a beneficiary. Those are useful tools. They can avoid hassle when you pass away, but they don't replace the need for a will, because there's almost always at least one or two probate assets, unless you've fully funded your trust, that we're going to need to look to the will to control. That might even just be the last paycheck that's paid to you, or the return of the unpaid amount of your AAA card. Those membership things, everything is being written to you, but you're dead, so that becomes a probate asset. And that's something that your will tell us what to do with. So even if you've got everything on a beneficiary, you still need a will. The other thing I like to encourage people to do is not have everything have a beneficiary designation unless you have a living trust. And the reason is that I've seen too many estates where what they're doing is they're starving the estate of any cash. So if you've named, say, the beneficiary of all your bank accounts to be your children, but your house is the one thing you still have your name on, and then you pass away, you've got your personal representative appointed to handle your house, but you've given them access to no cash whatsoever because all of the bank accounts got paid out to the beneficiaries. And so how are they supposed to pay your utility bills? How are they supposed to fix that leaking toilet that maybe never bothered you but needs to get fixed to get the best price for the house? So I really don't recommend that you do full-fledged 100% everything by beneficiary designation unless you've got a trust, which will itself have its own assets at that point in time. Bronte, can you change the slide, please? So we've talked about reviewing the roles, the role of the personal representative, the agent, the guardian, the healthcare agent. Bronte, you can change the slide again. So one thing I hear from a lot of people, though, is that when they look at those roles, they want to name more than one person. So, for example, I have 2 children. And if I think that I'm trying to be fair, I might say, I don't want to choose amongst my children. I don't want their feelings to be hurt. How about if I just name both of them? And my honest advice is that's usually not a good idea. I can't tell you that it's illegal. It is perfectly legal, but it often results in more hassle than you were trying to avoid. But if you're going to do it, these are the questions I ask you to think about. Are the people that you're naming able to work together? Are they shown before that they can work as a team? How will they resolve disputes? If I name my son and my daughter to work together as my co-personal representatives, what happens if they don't agree? Okay. What happens if one says, yes, I want to take this offer on the house, and the other says, no, I want to hold out for a better offer? So that needs to probably be written into your documents, into your power of attorney, into your will. What happens if they can't come to a conclusion together? There are also plenty of institutions, banks and mutual fund companies and the like, that won't allow 2 people to be named on an account as personal representative or as agents in a way that requires both of them to act. The banks no longer will allow you to set up an account that requires 2 signatures. They don't want to be responsible because no one's looking at those checks. It's all done by computer. So they will insist that either you have 2 people named and that they delegate the role to one another, so either one can sign the checks at any time or handle the bank in any way, or that only one be named to that role. So if you were so insistent that you wanted 2 people to act together, the banks are going to prevent you from being able to do that in many instances. And then when it comes down to naming a guardian, we have a lot of people who want to name a couple. Let's say I wanted to name my brother and his wife as guardian for my children. But I want you to think about that a little bit more and answer honestly, what happens if they're not together, right? Is it your brother that you really want to be guardian? Is it the sister-in-law that you want to be guardian? If you can't have the 2, what do you want? I always tell people that in the case of my brother, if he weren't married to her, I wouldn't want him as guardian because she's the best thing that ever happened to him. So I wouldn't want to know what happened to him if he got divorced from her. Okay. Bronte, can you change the slides, please? In addition to thinking about how your assets have beneficiaries, I want to think about how your assets are titled. When you own property with someone else, you are in joint ownership. And here in Colorado, you can have 2 different types of joint ownership. Joint ownership can be called joint tenancy, or it can be tenants in common. Those have 2 very different legal results when you pass away. If you are a joint tenant, let's say that I and my husband are joint tenants on our house. If I pass away, then he automatically inherits my house. If I am a tenant in common with him, when I pass away, my half of the house is controlled by my will. So they're very different in how the results can come to pass. The way to know if you are a joint tenant or tenant in common and in any property that you own with someone else is to take a look at the title, because it has to specify joint tenancy. If it is silent, then it will be tenants in common. So it will say something like as joint tenants, in joint tenancy, or on car titles in particular, it might be abbreviated to say JTWROS. So when that happens, then you want to know that you're a joint tenant. But if you can't find any of that language, it's likely that you are a tenant in common. Neither is the right answer, but both have to be done in a way that you understand the consequences. For joint tenancy, what you need to understand is that your will or your living trust will not control what happens to that property. That survivorship will. So if you had planned that you wanted your half of the house, for example, to go into a trust so that your spouse could not give it away to his new wife, then if you have joint tenancy, that's not what's going to happen. Even if your will has a wonderfully written trust about making sure that it's protected for your children, that's not going to happen with the house because the joint tenancy is going to override what the will says. Bronte, can you change the slide, please? In addition to thinking about whether the documents and the title and the beneficiaries are all what reflect what you want, you also have to give some thought to some changes in the law that have occurred in the last decades or so that might require you to actually have your plan reviewed by an attorney to see if those changes will detrimentally affect what you're trying to accomplish. One of the recent changes I alluded to, in December of 2019, we had an act come out called the Secure Act. Your financial advisor may have been talking to you about that because it has a lot of changes, particularly in the way that inherited IRAs are treated. And the way that those changes affect us as estate planners, or you when you have a document, is when you have that testamentary trust. It may result in some negative tax consequences for your testamentary trust when that trust inherits an IRA. And so it's best that it get reviewed by an attorney if you have any sort of trust that's created after your death and that you have had that done anytime before December of 2019. If you have your plan done before 2012, you probably don't reflect the new changes in the estate tax that mean that some of the complexities we lawyers were creating to avoid paying estate tax are not necessary anymore. These days, the only people who are going to have to pay estate tax in the state of Colorado are those who give away or leave during their lifetime a total of $11 million. So if there's no chance that you're going to be able to give that away and leave it at your lifetime, then maybe some of the complexities that were done in your plan before 2012 can be done away with because we don't have to worry about trying to. And then some very old plans, if they were fixed, may need to be redone to just reference HIPAA and some of the powers of attorney and the like. Bronte, can you change the slide, please? I think if you come away with nothing else today, one of the most important things I want you to know is that even the most wonderful documents don't do you any good if the people can't find them when they need them. So you should know where you're keeping the originals of your wills and powers of attorney and your HIPAA release, but someone else should know too, frankly, the people who might need to use them if you become disabled or when you pass away. So make sure that people know where those are. The original will is a pretty important one to have because it's the only thing that can go through probate easily. If you have a copy of a will, it will not be admitted to probate without going through a lot of hoops and may not be admitted to probate at all. So the best thing to do is make sure that you know where the original will is and you tell your personal representative how they can get at it. The other documents like powers of attorney can be used with a copy. And so that might be where you want to make sure that you've given copies to people or that you have digital copies available. Clients of ours have access to their client portal that always has digital copies, but there are third-party services that will hold copies for you if you don't want to just hold them on your hard drive. Some of those are called Everplans. There's one called Legal Directives. And those are all services that will hold those documents for you and actually give you a way to access them even if you're far away from home. And that's very useful, particularly for the healthcare documents. We have legal directives for a bunch of our clients so that even if you're traveling and you get sick, someone can get access to your healthcare power of attorney in your living will and know what needs to happen at the hospital. So there's places for that to happen. I'm not recommending any particular service or any particular method. What I'm just saying is this is part of the good planning that you want to do, is to make sure that you know where your documents are and that the people who need to access them know how to get a hold of them. Bronte, can you change the slide, please? So then this is, I'm going to go over this a little bit more quickly, but if you're a business owner, there's some more things I want you to think about when you're doing estate planning and thinking about it in this times of crisis. Does your business structure provide for transition of your control? What happens if you get too sick? Who, in accordance with your business structure or business documents, will be able to get access to your bank account? Will be able to continue working with your clients or working with your vendors? If you're sole proprietorship, then that's going to be through having a power of attorney and a will. If you're a corporation, the answer to that should probably be found in your bylaws. If you're a limited liability company, the answer should be found in your operating agreement. If you don't have bylaws or an operating agreement, we're starting to get into treacherous territory, because then we don't have anything to look to say, okay, our president's in a coma. How do we get someone else to be able to access the bank account? So given that some thought, if you have people who are involved in the business or involved in your life that you trust, you might now want to name them to positions where they can climb up into the top position pretty quickly. For example, you could have more than one person on your board of directors, or more than one person on your board of managers, or you could have vice presidents in addition to a president. In that way, if one member of the board is sick, the board can still act. If the president is sick, the vice president can step in. So especially if, for example, you're married and you've never really bothered to put your spouse on the business, this might be a time to think about it and think about putting them into one of these, let's call them standing in the wings roles. And that'll be helpful for you at that time. Bronte, can you change the slide for us, please? The other thing I want you to do as a business owner is determine who your fiduciaries are. Who's your agent? Who's your personal representative? If you have a trust, who's your trustee? And then give yourself a good thought, thinking to or talking to, I guess, about whether that person is the right one who can manage your business if you're sick or pass away. You might want to have someone who has a special role, like a special agent, who just handles your business assets. Because naming your husband might be great. If I named my husband to manage my affairs, he'd be great at everything but my office. He wouldn't know a clue about how to just even close down my business practice. So I probably should have a special agent in charge, and I do, to make sure that that happens in the event of my disability. Alternatively, at least I should let my husband know who I think he should hire on for that job as my agent, so that my practice can continue. Okay. Bronte, can you change the slide? We're not going to cover that. Can you change the slide again? All right. So, Bronte, did you notice any questions in the chat?
No, there are no questions in the chat. Unfortunately, I could not find the Facebook Live, so I could not see if there's questions there. But in the meantime, is there anybody in here? I can unmute you if you want to put your questions in the chat that we can cover there.
Or you can just unmute people and see if they've got anything they want to tell us.
Okay. All right, everybody is unmuted.
Are there any questions? Okay. What did Pat have to say on the chat? I missed it. Screwed up my screen and then it disappeared.
Oh, Pat said that she couldn't hear the audio on Facebook. Or they couldn't hear audio on Facebook.
Well, what we'll do is we'll get a copy of this if you want to hear it on your own. I'll also see if we can post it to Facebook. We did think that Facebook Live was going to be simpler than it turned out to be. So if we did have problems, I'm sorry to hear that. Okay. Anything else?
No, I'm sorry.
Send you an email with an evaluation asking you to tell us what we could do better next time. And obviously, improving on Facebook Live will be one of them. But let us know if there's anything in the program that raised any questions for you. And we appreciate that you joined us today.
Thank you very much, everyone.
Thanks, everybody.
Thank you, Karen.